Let's take a look at the National Labor Relations Act. The principal federal labor law that governs collective bargaining in private sector employees is called the National Labor Relations Act, referred to as the NLRA. Not all employees have union representation. In fact, the vast majority of private sector employees are not currently unionized. This does not negate the importance of understanding the NLRA and other labor law. For one thing, employees who are not currently represented by unions might attempt to unionize in the future. Non-union employees often have dealings with unionized contractors and suppliers. Mergers or acquisitions might bring unionized employees into the fold. Even if an employer does not have any dealings with unionized employees, non-union employees still have certain rights under the NLRA that must be respected. The NLRA and other labor laws also affect non-union workplaces and cannot safely be ignored by those employers. Joining together with other like-minded people often makes it possible to accomplish objectives that elude individuals acting alone. The institution of collective bargaining recognizes the value of employees banding together to deal with their employers and the fact that the desires of employees and employers sometimes clash. Both employers and employees care a great deal about and are apt to disagree on wages, hours, and many other terms and conditions of employment. Collective bargaining provides employees with representation, greater power in dealing with their employers, and a means for resolving issues in ways that meet the requirements of both parties. Labor unions play a critical role in collective bargaining by representing employees in their dealings with employers. Employees have the opportunity to choose by majority rule whether they want to have union representation. Unions negotiate with employers to obtain labor agreements, contracts specifying the wages and many other terms and conditions of employment for the employees that they represent. Then, unions have an ongoing role in representing employees, including filing grievances when disputes arise about whether employees' contractual rights have been violated. There is much to recommend about collective bargaining. Providing employees with a means of influencing important workplace issues that directly affect their well-being is entirely consistent with our democratic values. Rather than having to accept their employer's dictates or quit, collective bargaining gives employees the opportunity to exert a strong voice in the workplace. Another feature of collective bargaining is that the parties most directly affected by decisions about terms and conditions of employment get to decide the rules by which they live. As a consequence, the rules contained in labor agreements can be responsive to the particular needs of individual industries, firms, or workplaces as opposed to government-mandated one-size-fits-all standards. Despite these and other benefits, collective bargaining is widely unpopular in the US in terms of employer response. Certainly, employer views vary considering collective bargaining, but the typical response is hostility. Unions do a reasonably good job of increasing the share of corporate revenues claimed by employees and make it more difficult for employers to implement policies not favored by employees. Even though collective bargaining is a vital piece of U.S. public policy governing the workplace, the process of attempting to form unions and bargain with employers is often contentious and produces many legal claims. The National Labor Relations Act, the NLRA, is the principal federal law concerning self-organization and collective bargaining by private sector employees. The National Labor Relations Board, known as the NLRB, is the agency that administers the NLRA, including holding elections to determine whether employees desire union representation and determining if unfair labor practices have been committed. The Railway Labor Act is a federal law that governs collective bargaining in a highly unionized railroad and airline industries. It's administered by the National Mediation Board. State laws or executive orders provide collective bargaining by state and local government employees in more than 40 states. Collective bargaining by federal employees is governed by the Civil Service Reform Act and overseen by the Federal Labor Relations Authority. The details of these labor laws vary, but they all help assess employee desire for union representation and protect their rights to engage in collective bargaining. In contrast to most other laws that apply to all employees regardless of organizational position, the NLRA's protections do not apply to supervisors and managers. Under the NLRA, supervisors are individuals who have the authority in the interest of the employer to make personnel decisions, to responsibly direct other employees, to settle their grievances, or to effectively recommend such action. This definition of supervisor is intended to distinguish positions that are genuinely part of management from employees who operate like team leaders from professionals in general. Managerial employees who formulate and effectuate management policies by expressing and making operative the decisions of their employer are also excluded from coverage. It was no doubt that the news to many professors at Yeshiva University, a private college, when the Supreme Court ruled in 1980 that they were managers. The court reasoned that the faculty's role in making decisions about such basic matters as determining curriculum, hiring faculty, and granting tenure was managerial authority exercised in the employer's interest. Of course, much has changed on the higher education scene since 1980. Full-time, tenured faculty members of the sort that the Supreme Court had in mind have become increasingly rare. The cadre of part-time, adjunct faculty who are clearly not managers has grown substantially, and they've obtained union representation at a number of schools. Additionally, state public employee collective bargaining statutes have generally been interpreted as covering faculty members. If you are a student at a public university, the faculty members at your school might be unionized. There is one significant exception to the general rule that supervisors and managers fall outside the NLRA's protections. In one case, a manufacturing supervisor claimed that he was terminated in retaliation for his refusal to help the company build a case that it could use to fire 2 employees who were attempting to organize a union. The court made it clear that a supervisor or manager who is disciplined for refusing to commit unfair labor practices is protected by the NLRA. The NLRA does not directly affect employment outcomes, but provides employees with a means of acting in their own interest to improve their terms and conditions of employment. The fundamental rights conferred by the NLRA, often termed Section 7 rights, include the right to do the following or refrain from such activity: to engage in self-organization, form, join, or assist labor organizations, bargain collectively with the employer, go on strike, and engage in concerted activity. The self-organization and concerted activity protected by the NLRA is broadly construed. Concerted or group activity is not confined to formal collective bargaining conducted by unions. Instead, any efforts by employees to join together for mutual aid or protection can qualify as protected concerted activity, even if those employees are not represented by a union or attempting to form one. What makes employee actions concerted? In general, conduct must be engaged in, with, or on the authority of other employees, and not solely by and on behalf of the employee himself, to be concerted. Evidence of group activity, such as discussions among employees or the delegation of an employee to speak with management, is generally necessary to demonstrate that the activity is concerted. However, for unionized employees, a complaint that relates to enforcement of rights under a labor agreement is concerted activity even if it's raised only by an individual because it affects all employees covered in the agreement. The NLRA is also violated when an employer terminates an employee to prevent that employee from exercising her right to engage in concerted activity. To receive protection, an employee's actions must be concerted and be for the purpose of mutual aid or support. Even when it's undertaken for mutual aid or support, concerted activity by employees is not always protected. For one thing, the activity must be related to employees' concerns regarding their wages, hours, and terms and conditions of employment. Second, the manner in which the activity is carried out must not be extreme or abusive. In policy prohibiting negative conversations about coworkers or managers violated the NLRA because of the likelihood that employees would view the rule as prohibiting complaints about management decisions. Employees must not discipline or discharge employees engaging in protected activity under the guise of workplace conduct rules by declaring union organization to be harassing. However, employers still have an opportunity in such cases to assert an affirmative defense by showing that the disruptiveness of the act and not merely its violation of the policy was the reason for imposing discipline. Today, employee complaints about their terms and conditions of employment are as likely to be aired electronically through social media sites as they are to be voiced in person around the water cooler. But fundamentally, the issue is still whether the employees initiating such communications and any coworkers responding to them are engaging in protected concerted activity. Employers in both unionized and non-union workplaces must respect the right of employees to join in expressing concerns regarding their terms and conditions of employment. To protect employees' rights to self-organization and give collective bargaining a chance to work, the NLRA prohibits certain actions by employers and by unions. These unfair labor practices, known as ULPs, are listed here. Employers must refrain from the following activities: interfering with employees in the exercise of their rights under the NLRA, interfering with the formation or administration of a labor organization, discriminating against employees to discourage union membership, retaliating against employees for filing charges or giving testimony under the Act, refusing to engage in collective bargaining. Labor organizations must refrain from the following activities: coercing employees in the exercise of their rights under the Act, causing an employer to discriminate against an employee for union membership, refusing to engage in collective bargaining, broadening labor disputes to include neutral employees, charging discriminatory initiation fees, and causing an employer to pay for work not performed. The first category of employer ULP, interfering with, restraining, or coercing employees in the exercise of their NLRA rights, encapsulates employers' legal obligations under the NLRA. The remaining employer ULPs are elaborations on this general requirement. The prohibition against employer domination of a labor organization or interference in its administration needs explanation. The underlying notion is that to be a bona fide employee representative, labor organizations must be independent of employers. This requirement of independence holds not just for labor unions, but also for labor organizations of any kind. The definition of labor organization under the NLRA is broad. A labor organization is any organization or employee representation committee which exists for the purpose of dealing with employers concerning grievances, wages, hours of work or employment, and conditions. Clearly, employers are prohibited from creating or controlling company unions that do not genuinely represent employees' interests, but the NLRA also has implications for employee involvement groups and work teams. Employee involvement takes on many forms, but typically involves groups of employees interacting in some fashion with managers to discuss production, safety, or other issues. The NLRA comes into the picture because employee involvement groups can be deemed labor organizations dealing with employers regarding employment matter. And if the groups are labor organizations, they will almost certainly be considered dominated because they're initiated by an employer. Thus, their existence can violate the NLRA. One unionized employer violated the NLRA by setting up a company-dominated employee involvement team that dealt with such issues as safety and benefits. Furthermore, the NLRB concluded that the employer was bypassing the employee's representative and not meeting its legal obligation to bargain only with the union in these items. Employers also commit a ULP by discriminating against employees for the purpose of either encouraging or discouraging membership in a labor organization. Thus, employers cannot refuse to hire, fire, demote, or otherwise limit the employment opportunities of employees because they're known or suspected to be union activists or supporters. As in other disparate treatment discrimination cases, proving the motive behind a challenged employment decision is crucial. Unions are formed over a period of time, sometimes months, sometimes years, in which employees dissatisfied with their treatment by their employer become convinced that unionization is the best way to improve their lot. As an organizing campaign develops momentum, there is typically much discussion and persuasion among workers, rallies, and requests to sign petitions. Non-employee organizers from established unions often play an important leadership role, but for the most part, employees organize themselves. If sufficient support is established, the NLRB might be petitioned to hold an election to determine whether a union will be certified as the legal representative of the employees. Employers faced with organizing campaigns might be tempted to ask employees what their attitudes are towards having a union or whether they intend to vote for the union. Making these types of inquiries is not an automatic violation of the NLRA, but there tends to be intimidating and coercive even if not accompanied by explicit threats. Under limited circumstances, systematic polling of employees regarding their union views is allowed, but by and large, employers should refrain from polling employees to find out who supports unionization. Videotaping or photographing employees engaged in lawful organizing activity is also likely to be considered intimidating. Absent legitimate justification, these actions violate the NLRA. Although some employers agree to remain neutral during organizing campaigns, employers are generally free to make their views about the merits of unionization known to employees. Except for the 24-hour period immediately preceding NLRB representation elections, employers are free to require employees to attend meetings at which the employer's views about unionization can be presented. The NLRB does not police the truthfulness of statements made in the course of organizing campaigns unless the board's processes are misrepresented, forged documents are created, or inflammatory appeals based on racism are made. However, employers and unions are prohibited from making statements that contain threats of reprisal or force or promises of benefit. Employers must refrain from threatening employees as a means of influencing their decisions regarding unionization. Although employees cannot be threatened, employers can make predictions about the likely consequences that unionization will have for the business. After an organizing campaign is underway, and especially if the election has been ordered, employers risk violating the NLRA if they raise wages or make other previously unscheduled changes in employment benefits. Termination of pro-union employees for their organizing activity is an all too common occurrence. Employers must not discharge or otherwise discriminate against employees because of their efforts to organize a union. Such terminations are a clear affront to the rule of law and any sense of fair play. This does not mean that employees can never be terminated in the midst of organizing campaigns. Claims that employees are no longer interested in unionization carry little weight when employers regularly resort to terminations and the threat of terminations to defeat employees' desires for unions. In general, employers must allow employees to engage in discussions about unionization in the workplace during non-work time. An email is a primary mode of workplace communication for many employees. Employers' ability to restrict solicitation via email is of great practical significance. Currently, the NLRB suggests that employees with access to their employer's email systems in the normal course of their work generally must be allowed to use it during non-work time to engage in communications protected by the NLRA. Employers generally should not prohibit use of their email systems for organizing activity during employees' non-work time, especially if employees are permitted to use within reason email for non-work purposes. In general, employees must be allowed to wear union buttons or display insignias and to engage in activities such as lunchtime rallies. When union organization is going on, employers should ensure limitations on personal appearance policies in the workplace are justifiable and not discriminatorily enforced against union proponents. Non-employee organizers, union employees, and community activists who assist employees in forming unions are often critical to employees acting on their rights under the NLRA. As long as they have another way to reach them, employers with non-discriminatory, no solicitation policies can deny non-employee organizers access to workplaces. The NLRA sets out procedures for determining employee choice through representation elections. But which employees will be able to vote? Employees of a company hold many different job titles and are often spread across numerous workplaces, departments, and divisions. The NLRB is responsible for ensuring that the group of employees for which representation is being sought constitutes an appropriate bargaining unit. If union representation is chosen, the success of collective bargaining is affected by whether the employees in the bargaining unit have sufficient common interest. For the most part, the NLRB determines the appropriateness of proposed bargaining units on a case-by-case basis. The primary criterion used by the board is whether the employees share a community of interest. Among the indicators used to determine community of interest are similarity in skill levels, interrelationship of tasks, and common pay systems, supervision, and personnel policies. Certain provisions of the NLRA also limit the makeup of bargaining units. The typical path to union representation under the NLRA proceeds from an organizing campaign to employees petitioning the NLRB to hold a representation election. One of the main requirements for the board to order an election is a showing of at least 30% of employees in appropriate bargaining units' desire for union representation. This showing is typically made by employees signing authorization cards. To be valid, these cards must be current and indicate the desire for representation by a particular union. Under the NLRB's formal certification process, the authorization cards are not the representation election, rather, evidence that the election is warranted. The board will not hold repeated elections for the same group of workers. If there was a prior election within the past 12 months, an election will not be ordered. Also, if the employees are already represented by a union and covered by a collective bargaining agreement, an election to change representatives will be ordered only during a brief window period prior to or after contract expiration. If an election is ordered, the employer is required to provide the NLRB within 7 days a list of names and addresses of all employees in the bargaining unit to give the union a chance to contact all employees who might be interested. During this time, between when an election is ordered and when the election is held, employer and union conduct is subject to a particularly close set of scrutiny. In rare cases, an employer's misconduct prior to an election is so severe that the board will certify a union that had shown majority support through authorization cards and require the employer to bargain even though the union lost the election. Representation elections are secret ballot elections held under the supervision of the NLRB and generally in the workplace during work time. Election observers can be chosen, but they must not be managers or supervisors. If the majority of employees who actually cast votes choose union representation, the NLRB will certify the union as the exclusive representative of all employees in the bargaining unit. The NLRA also provides for decertification elections, in which employees decide whether they want to continue to have union representation. Employers cannot interfere by encouraging employees to decertify their unions. Voluntary recognition of a union by an employer is also permitted under the NLRA as an alternative to certification following the holding of a representation election, provided that there is evidence of uncoerced majority support for the union. Frustrated by delays and by what they see as employer manipulation of the representation election process, unions are increasingly seeking to obtain recognition through a card check procedure. In general, this entails obtaining the employer's agreement to recognize the union if a majority of employees sign authorization cards. A neutral third party is designated to verify results. Under this procedure, authorization cards serve as the decisive indicator of employee preference and not merely as a means to obtain elections. Unions going this route often attempt to negotiate neutrality agreements, whereby employers pledge to remain neutral and not oppose unionization. Some legal questions have emerged regarding the use of these neutrality agreements. Although they have generally been upheld, one appeals court found that a provision of the NLRA prohibiting employers from providing anything of value to unions was violated by the promise of neutrality. The union status as an exclusive representative is important. In practice, it means that unionized employers must generally refrain from dealing with individual employees regarding their wages, hours, and terms and conditions of employment. Representation by a union is distinct from membership. Many employees choose to become union members, but the union is legally required to represent all employees in the bargaining unit. The NLRA also permits states to pass laws making it illegal to incorporate union security provisions into labor agreements. These are known as right-to-work laws. More than half of all states are right-to-work states and have chosen to enact these laws. The law does not and cannot ensure that collective bargaining will result in an agreement. However, good faith bargaining is required. The NLRA does not go very far in defining what this means. It refers to the obligation to confer in good faith with respect to wages, hours, and other terms and conditions of employment. There is a mutual obligation of the employer and the representative of employees to meet at reasonable times and to execute a written contract incorporating any agreement reached. Because parties to a collective bargaining relationship are free to engage in hard bargaining and need not reach agreement or even make concessions to the other party, identifying when there's a lack of good faith is difficult. However, actions such as imposing conditions on the holding of negotiations, inhibiting or delaying negotiations, withdrawing accepted offers, are indicators of a lack of good faith and should be avoided. Good faith bargaining entails sharing information. As a general matter, employers are required to supply unions with requested information that is relevant and necessary to representing employees effectively. This information is usually limited to wage and other employment data directly related to bargaining issues rather than financial data. However, if an employer asserts that a union demand cannot be met because of financial constraints, the employer will have to provide financial information if it's requested to substantiate the claim. Bypassing union representatives and appealing directly to employees constitutes refusal to bargain with the legal representative of employees. Employers also fail to show good faith when they make material changes in employees' terms and conditions of employment without informing and negotiating with unions over these changes. The duty to bargain pertains to wages, hours, and terms and conditions of employment. This phrase is given broad reading under the NLRA, but it does have some boundaries. The NLRB distinguishes between mandatory and permissive or voluntary topics of bargaining. A mandatory topic is an issue that, if raised by either party, must be negotiated over. Furthermore, disagreement over a mandatory topic is a sufficient reason for failing to reach agreement in negotiation. By contrast, if a permissive topic is raised, the other party can decline to discuss it. Moreover, if a permissive topic is discussed but not agreed on, it cannot be the basis for failing to come to terms. The many mandatory topics of bargaining include wages, bonuses, benefits, work schedules, safety, layoff and recall procedures, and grievance procedures, to cite only a few. Permissive topics are all non-mandatory topics that are not illegal to incorporate into a labor agreement. Proposals in collective bargaining come from both unions and employees. When employers are facing severe financial or operational problems, they are usually anxious to reach agreement on terms that will enable them to lower their labor costs or operate more efficiently. Employers are generally required to abide by the terms of existing labor agreements, even when those agreements have expired. Only after a labor agreement has expired and a valid impasse exists are employers free to unilaterally implement their last best offers made during negotiations. An impasse is reached when negotiations over one or more mandatory topics have become deadlocked and both parties are warranted in assuming that further negotiation would be futile. An impasse is not necessarily a permanent state of affairs. That is, it can be broken by one or both parties later relenting and making further concessions to the other. Distinguishing a genuine impasse justifying unilateral implementation of terms from an illegal refusal to bargain in good faith is a challenging task. For the most part, unions and employers are on their own when it comes to bargaining. The assistance of outside parties can be helpful in negotiations, but usually is not legally required. Mediators are neutral third parties who, by entering the negotiations and exerting control over the bargaining process, help unions and employers reach their own negotiated settlement. Mediators can only facilitate negotiations. They have no authority to impose agreement or any particular terms on the negotiating parties. The NLRA requires that the Federal Mediation and Conciliation Service be notified within 30 days after bargaining is requested if an agreement has not been reached in the negotiation. The agency is charged with communicating with the parties and using mediation to produce agreements and avoid strikes. However, if the negotiating parties do not want to settle, there is little that a mediator can do. Mediators have more strength under the Railway Labor Act. Only when the National Mediation Board concludes that further negotiations would be fruitless are the parties allowed to pursue a strike or other approaches. Airline industry negotiations overseen by the National Mediation Board sometimes take several years to conclude. Fact-finding procedures that delay strikes are used in rare circumstances under the NLRA and somewhat more frequently under the Railway Labor Act. Only rarely does the law require that negotiating parties turn over unresolved issues for resolution by an arbitrator. Perhaps the most highly publicized and dramatic manifestation of labor relations is the strike. However, despite the hold that strikes have on the public's imagination, the vast majority of negotiations conclude successfully without strikes. In a strike, employees withhold their labor, refusing to resume work until their employer agrees to more favorable terms and conditions of employment or refrains from engaging in unfair labor practices. Strikers are not quitting their jobs, but rather attempting to place pressure on the employer to act differently. Strikes and the threat of strikes play a vital role in negotiation. Because employees can credibly threaten to impose unwanted costs on employers through the disruption of production, employers have a strong incentive to bargain seriously, compromise, and attempt to reach agreement. Strikes can also impose costs and pose potential dangers for employees and their unions. There's no guarantees that strikes will succeed. Thus, the strike option gives both management and labor good reason to bargain seriously. Strikes and associated activities such as picketing are concerted activity. As such, strikers are generally protected by the NLRA, and private employers must not terminate employees for engaging in lawful strikes. Although the right to strike is protected under the NLRA, federal government employees do not have the right to strike. Many state and local government employees are also prohibited from striking. Strikers engaging in lawful strikes cannot be terminated, but they can be replaced. Economic strikes are undertaken to pressure employers to meet employee negotiation demands. The issues in dispute need not be money issues. Unfair labor practice strikes are undertaken in response to an employer's ULP, like refusal to bargain in good faith for the purpose of pressuring employers to comply with the law. In any strike, employers can cease operating or operate using management personnel only. If employers choose to use replacements for striking employees, the distinction between economic and ULP strikes becomes relevant. In economic strikes, employers can hire either temporary, for the duration of the strike, or permanent replacements. However, if the hiring of permanent replacements is motivated by a purpose prohibited by the NLRA, it is illegal. Strikers who are permanently replaced remain employees and have the right when the strike is over to be placed on a recall list, notified of available job vacancies, and rehired if possible. Strikers in a ULP strike can be temporary but not permanently replaced. Employers must reinstate unfair labor practice strikers who make unconditional requests to return to their jobs. Whether a strike is a ULP strike is not certain until after the NLRB has ruled. If the NLRB decides that a strike was responsive to an unfair labor practice, replaced strikers are entitled to immediate reinstatement and substantial back pay. At the same time, if employers confer permanent status on replacements in strikes that turn out to be ULP strikes, the replacement workers who must be discharged have grounds to sue for breach of contract. Strikers sometimes lose legal protection because of behavior they engaged in during a strike. In picketing, employees gather near the workplace and through words or signs make it known that they have a dispute with their employer. Picketing that restrains or coerces other employees who have the right to refrain from concerted activity is not protected and, under some circumstances, violates state criminal law. Mass picketing that does not allow picket lines to be crossed, actual violence or clear threats of violence against non-strikers, destruction of employer property, and similar conduct are not prohibited. Picketing generally must be limited to the primary employer. Other secondary, neutral employers cannot lawfully be picketed. Under certain circumstances, employers can legally engage in a lockout of employees. Many work stoppages are, in fact, lockouts initiated by employers rather than strikers. Following the expiration of any labor agreement, an employer might choose to withhold from employees the opportunity to work despite their willingness to remain on the job and continue negotiating. The employer might do so because it fears that a strike will take place later at a disadvantageous time, or it might do so to put more pressure to settle on the union that it's reluctant to strike. Courts have allowed employers to use temporary replacement for locked out employees. Lockouts have become commonplace in professional sports. A lockout is illegal if the purpose of the lockout is to defeat employees' right to have a union. Negotiations that conclude successfully, either without or after a strike, result in written or signed labor agreements. Most unions require that agreements be approved or ratified by their members before they become final, but ratification procedures are not a legal requirement. Labor agreements are a very important document. They are the basic source of rules governing the wages, hours, and terms and conditions of employment for unionized employees. The provisions they contain typically go well beyond minimum legal requirements. Labor agreements contain enforceable contractual protections for employees. Employers must abide by the terms of labor agreements when making human resource decisions regarding employees represented by unions. Managers must be thoroughly familiar with any labor agreements that cover their employees. Rather than require lawsuits every time an employee's rights have been violated, labor agreements usually provide grievance procedures ending in arbitration if necessary. Employees who believe that their contractual rights have been violated can file grievances, or unions will do so on their behalf. The grievances will be considered by successively higher levels of management and union personnel. The representative role of the union must be respected in the contract administration process just as during negotiations. Although individual employees can choose to file and pursue their own grievances, unions must be notified and given opportunity to have representatives present at any meetings about grievances. Most importantly, individual employees and employers cannot agree to resolve grievances in ways that would alter or conflict or contrast the labor agreement itself. The availability of a grievance procedure also means that employees cannot take contract enforcement into their own hands, such as by refusing to follow orders that they believe are contrary to the labor agreement. Instead, they're required to follow the orders and file a grievance. If a grievance is upheld, the employee will receive a remedy for the violation. Grievances that cannot be resolved by conferences between representatives of labor and management are sometimes submitted to arbitration. Ultimately, the union decides whether to take a case to arbitration. In grievance arbitration, the arbitrator decides disputes regarding the interpretation and enforcement of an existing labor agreement. The courts have made it clear that arbitration is the preferred means of resolving disputes about rights under labor agreements and that arbitrators' decisions are generally final. Arbitrators have a great deal of leeway in interpreting labor agreements, but their decisions still must be grounded in or draw their essence from the language of those agreements. Labor agreements between unions and employees are more than words written on paper. Grievance procedures and arbitration are critical in defining the rights of the parties under the labor agreement. Employers should handle grievances and arbitration cases very carefully, including gathering the facts and carefully considering which cases should be settled or allowed to go to arbitration. The labor agreement sometimes extends to ongoing practices of the party, even when these are not explicitly or not at all mentioned in the labor agreement. A change in circumstances, like the installation of new equipment, or in contract language, is likely to invalidate a prior practice. Past practice cannot be cited to create rights that conflict with the clear and unambiguous contract language, but it can be important in supplementing labor agreements when they're silent or unclear on a given matter. After all, it's reasonable to assume that the issue presented in a grievance has been dealt with before, and the manner in which it was handled conveys important information about how the parties understand the agreement. In light of the importance of past practice in arbitration, unionized employers should not establish informal practices of conferring benefits or privileges not specified in the labor agreement unless they are willing to sustain these practices. Both employers and unions have a responsibility to ensure that it's being enforced in a manner consistent with the understandings at the time the agreement was reached.